Thank you, Stephen, and good afternoon, ladies and gentlemen. For those of you that know me, did you ever think you would ever see the day when I would share the stage with a bishop? No, neither did I. Well, another year has flown by in the Enforcement Division, and there seems to be no slowing down in matters being referred to us for further investigation by the Commission's supervisory divisions. On reflection, I was clearly being rather optimistic when I first said to the Director General some 3 years ago that I thought it would take possibly 3 to 5 years for things to settle down and for firms to ensure that proper adherence to the laws were in place. I am clear now in my own mind that there will always be the minority that will flaunt the laws of the bailiwick and the 99% of you that abide by them. It therefore follows that there will always be the need for the Commission to have an enforcement division. I am constantly asked by members of industry if I see more serious matters in certain finance sectors, and I cannot necessarily say that I am. What I can say is that in the fiduciary sector, it seems to be mainly focused on poor adherence to the AML-CFT handbook, in particular on how high-risk relationships are being managed, along with corporate governance issues. However, it is within the funds sector where we have seen some pretty serious failings in corporate governance, management of conflicts of interest, management of clients' assets, and in some circumstances, what we have seen has led us to believe that the contraventions are bordering on dishonest. Of course, if we see evidence of criminal behaviour, then we refer that to our colleagues at the Economic Crime Unit. It is therefore cases within the funds sector where we are currently having to deploy the majority of our resources in the Enforcement Division. As most will know, as a result of our findings, we have found it necessary to make application to the courts for administrators or liquidators to be appointed in some cases, which is time-consuming, it's very expensive when we have ongoing investigations into the matters which led them to be in the position they found themselves in the first place. It will come as no surprise to anybody here that the Providence scenario is receiving a great deal of attention from ourselves and others, and for obvious and understandable reasons. There's been a lot written and said by a lot of parties, and there's obviously been a lot of media releases. And as much as I would like to comment on the issue here today, due to the ongoing investigations, I cannot for obvious reasons, which I'm sure you can all fully understand. However, I'm sure all here today will be as concerned as we are regarding the reputational risk to our industry when matters like this arise. Over the past year, the division has endeavoured to reach out to industry, and I have delivered 2 formal presentations which included interactive sessions for members of both the Guernsey Association of Compliance Officers and the Institute of Directors with the Guernsey International Business Association, which I will go into a little bit more detail shortly. The theme of this year's industry presentation is around culture, and it is one that, for me, highlights what you can potentially expect to find in a firm once you have assessed the type of regime that exists at board level. We hear the buzz phrase regarding the tone from the top, and it is absolutely true. I will talk more about this when I also give you some broad brush examples of poor culture that we have discovered during our investigations. I also want to talk a little bit about a couple of recent enforcement cases which have been appealed to the Royal Court after the Commission's senior decision makers released their final decisions. I will touch on the highlights of these appeals and hopefully provide a balanced viewpoint, which is something which appears to be missing on occasion from statements issued and interviews given by the legal representatives of some respondents who may sometimes like to give the impression that they have had a resounding victory on behalf of their client and perhaps implied that the Commission has had its knuckles rapped by the Royal Court, when in fact their client is in prison or prohibited from carrying on any regulated activity, and who in reality might have been successful with just 1 or 2 points in the whole appeal process. Nevertheless, some good points have been identified by the courts as part of the process, and we have taken steps to address those accordingly where we have been asked to do so. I would also like to share with you some brief statistics regarding other offshore jurisdictions around the globe, as I wanted to assess how we compared with others with regards to the levels of sanctions that were being brought. This is all part of ensuring that what we do remains at all times both reasonable and proportionate. If we can move now to outreach and what we have achieved this year. As I said, in February this year, I was invited by GACO to provide a case study presentation to its members, who broadly comprise the industry's compliance officers. In taking a lead from a similar presentation I'd seen from my colleagues in Jersey, I used a handset systems to ensure that everybody could get involved, instead of simply listening to me for an hour or so, which would have been incredibly tedious and boring. I was then invited jointly by the IOD and GIBA to provide the same presentation in June to their members. So in effect, we had one for compliance officers and one at board level. I am pleased to say that the results were very similar. What I was looking for, purely from my own personal point of view, was to see whether the compliance staff were answering everything in a manner which we would expect from professionals in their field, and then the board of directors coming up with a different set of answers when looking at it from a business perspective. Hence, it was pleasing to see similar answers being provided by both groups. It was the first time we had tried something like this, and I'm hoping it provided an insight for those who attended into the types of cases we have been dealing with and the reasons why we brought the sanctions that we did against either the licensee or the individuals. I also hope that those who attended the sessions found it both interesting and helpful, as in essence we want to try and ensure that the failings identified across these cases do not happen again in the future. Maybe in the future we will do a similar exercise, perhaps using fewer cases, but instead providing a deeper dive into each case. I would imagine that these will be very much funds-based and around culture, corporate governance, and conflict management that arose within those firms and structures. Which leads me nicely onto corporate culture. I would like to share with you a few examples of poor conduct and culture. The standout cases for me over the last 12 months are that of Bordeaux Services and Confiance Limited. With the latter, we discovered a firm that appeared to be driven on profit, with a lack of prioritisation given to the compliance function by the directors, in particular to ongoing monitoring of relationships. This, together with the failure of the directors to ensure remediation was effectively undertaken following prior identification of issues by the Commission, led to mistakes being made over risk classification of clients, the due diligence process being incomplete, and in some cases being almost non-existent. It was very disappointing to find experienced professionals failing to adhere to the regulatory regime in such a fashion. But for some of them, they ended up paying a high price for not fulfilling their responsibilities as directors. This case very much highlighted the tone at the top, where you could see that there was either little attention being placed to the laws, and in some circumstances, it was all about getting the clients in the door and worrying about the compliance and their own risk appetite later on. It was evident that they had not moved with the times and were still working to a regulatory regime of years gone by. We've heard today how, from all of the speakers, how we need to move on in the way that we deal with the regulation that's always coming at us. The board never made the shift from can we to should we, and this is where culture comes in, because it's part of it will be what you do when there are no rules to guide you. In the case of Bordeaux, it was how they carried out their role as designated manager with regards to the Arch funds, which is common to us all. The decision reached questioned whether they carried out their functions effectively and robustly when confronted with a dominant fund manager that was very much calling the shots. In effect, what was discovered here was a classic example of a group of directors who did the bare minimum to get by and did not want to rock the boat as it provided a reasonable percentage of their annual income. However, there were serious systemic failings at board level with regards to corporate governance. Amongst other things, there were poor records kept, which meant that the level of oversight on the role of the investment manager was significantly reduced by not maintaining or having sight of original documentation. Minutes of board meetings were not accurate or complete. The NAVs were wrong, albeit there was no allegation that was deliberate, more that it was sloppy work. There was also no evidence to demonstrate how they managed the conflicts of interest that existed, where some of the directors also sat on the board of the fund. The compliance monitoring programme was deficient and no serious attempt was made to improve it. All worrying signs from a regulator's point of view. Whilst carrying out some research, I came across a speech made by Nick Kinnock from the New Zealand Financial Markets Authority, where he comments as follows. To state the obvious, compliance negates enforcement, and it is far better for all concerned that there is a focus on compliance rather than enforcement. Ideally, you are dealing with our supervision teams rather than interacting with investigators. And it goes on. And when I say compliance here, I mean outcomes for customers rather than a tick box exercise. I could not agree with that comment more. The message I would like to get across is that if the conduct and culture are right in a firm, you are much less likely to be facing potential enforcement sanctions. Such an approach is something that the Commission fully supports, and again is a message that I have given previously. We would much prefer our firms to be dealing with our supervisory teams than find themselves in the enforcement process when they're dealing with the guys from my division. In this respect, I found a recent article which appeared in the Guernsey Press both interesting and insightful, where it was talking about how the previous gap in the relationship between industry and regulator had been bridged. One comment which was particularly amusing was the reference to how a licensee potentially thinks a regulator perceives risk, and I quote, "Business is very risky. If we think you aren't managing them, we will come down on you like a ton of bricks. Here is how we want you to manage them. If you don't do it this way, then you will wake up with a dead horse's head next to you." I am very pleased to say that it is not quite like that. However, following on from this rather horsey theme, the only similar analogy I can draw is thus. You can lead a horse to water, but you cannot make it drink. This is very true in some of the investigations we have carried out, where beforehand supervisors have shone a torch on the areas that need improving upon, and the firm has failed to take up the baton and do so, and they've ended up in the enforcement arena. If I may, I'll refer back to Nick Kinnock from the New Zealand Financial Markets Authority, as I agree with his comments. The FMA does not prescribe culture. We are not the culture police. A firm sets its own culture. We think that culture is set and influenced from the tone at the top, but we are cognizant that people's role models are not necessarily the CEO or the chairman. The role models may be their line managers or team leaders. Staff will also look to identify what is deemed as appropriate behaviour and what is ignored, and how those staff members are potentially rewarded. I will leave it there on culture, as it is a topic that we could discuss for many hours, I'm sure. I would now like to address the appeals that have been brought before against the decisions of the Commission's senior decision makers. And just to remind everyone again this year, our senior decision makers are taken from a panel of QCs that sit alone on each case when it is referred and where matters have not been able to reach any agreed settlement. I am hoping that now we have been appealed before the Royal Court and the Court of Appeal on a couple of occasions, and the Court has supported, on the whole, the cases we have brought sanctions, that the minority, and I have to emphasise here, the minority within our industry will start to take notice of the standards expected. In the cases of Mr. Merrion, Mr. Gordon and Mr. Galliers, who now all serve custodial sentences following separate investigations by the Economic Crime Unit, we had brought sanctions against them or their firms in the first instance before the criminal cases were prosecuted. Of the appeals that have been heard, with regard to Bordeaux services, the Court asked the Commission to review the prohibition against one of the directors and reconsider the quantum of the original financial penalty which had been levied against the licensee. The Commission's senior decision-maker was asked to consider those remitted aspects, and he subsequently decided to reduce the financial penalty to £50,000 on the licensee, and the prohibition against one of the directors was reduced to 2 years. The other sanctions remained untouched by the court. In the case of Mr. Merian, the sanctions of a lifetime ban from the industry and a detailed public statement were not changed by the court. And although the court asked the Commission to look again at the financial penalty which had been levied against Mr. Merian, it did not suggest that the fine should be dropped altogether. The decision to drop the financial penalty was subsequently reached by one of our senior decision makers, following reconsideration of the matter, where he noted that since the original decision to impose such a penalty, that Mr. Merian had been convicted and he was in prison for fraud offences. He noted that Mr. Merian had no material income and no substantial assets from which he would be able to satisfy a financial penalty, and there was no prospect that he would be in a position to do so within the foreseeable future. The court also made some further findings with regards to the Commission's powers on the Financial Services Commission law, which were not as far-reaching as a recent promotional press article from a law firm would have you all believe. The points raised by the court had nothing to do with the method or the quality of the investigation which the Commission undertook, nor the quality of the evidence provided. Rather, the principal points made by the court were around ensuring that if the Commission's guidance document on the decision-making process had been departed from, there should be proper reasons for that departure within the decision. It also expected that full reasoned decisions should be made out by the senior decision-makers when they sit alone on these cases. Of course, the Commission will continue to take note of the points that the court has to raise going forward, but on the whole, we are content that our actions have not been deemed too unreasonable. Global statistics. When I spoke to the Institute of Directors seminar earlier this year, I gave more detail than I intend to provide here. However, I thought for the purpose of today, I would concentrate on two areas, those being financial penalties and prohibitions. As a young law enforcement officer learning my trade, which was clearly only a few years ago, I was told that planes, cars, bikes and vessels do not smuggle. It is the people who operate them that do. If you transfer that simple thinking to our finance industry, I don't think I have made any secret of my belief that it is not the name over the front door that leads a firm to fail. It is the boards and the senior management running a firm that are responsible for a firm failing to meet its regulatory obligations. I firmly believe that this is compounded where there have been losses to investors or there is potential for losses to investors. If you look at the first slide regarding financial penalties, clearly the bigger jurisdictions are going to be levying much larger penalties on the bigger firms that have not acted accordingly. What I would ask to what end? If those that made the companies fail remain in place, as you can see, Hong Kong and Dubai are much heavier on financial penalties. However, when you move to prohibitions, I question whether this is actually working, as those particular jurisdictions appear to leave those that made the firm fail in situ. It is clear that both Jersey and Guernsey are seeking to remove the wrongdoers from their positions, but only when we believe it is appropriate and reasonable to do so, and for a period of time conducive to the severity of the findings made against them. There is a change in approach in the UK now with regards to this, with the senior managers regime, which the chairman talked about earlier. And it is placing more emphasis on the directors and the senior managers to be accountable for failings within their respective firms. I believe this is the right way of addressing the issue, as the levying of nearly £150 billion worth of fines against banks since 2008 does not seem to have changed the culture within, and can be regarded as merely punishing relatively innocent shareholders. In some circumstances, we are seeing the same global names receiving massive financial penalties, but not one member of the board has had sanctions brought against them for any wrongdoing. Taking action against an individual is a serious step for a regulator to take, as in effect it could potentially end someone's career. However, this has to be balanced against the damage that these people can do and cause to investors and customers if left unchallenged and still in a position to carry on the wrongdoing that has already been discovered. From our perspective, we will continue to look at the role played by the boards when assessing firms. And of course, each case will be treated on its own merits. However, where we have seen serious or systemic failures after previous warnings being given and there has been either a loss to investors or there is the potential for a loss to investors due to the behaviour identified, then people can expect the full regulatory toolbox to be used for the protection of others. And I think that is a reasonable and proportionate approach to take in matters such as these. The last thing from me today is regarding this perception, which I believe still exists, that once referred to enforcement, then that is it. You will end up with sanctions brought against you, as I personally will not be happy until I see that happen. That could not be further from the truth, as that is only the start of the investigation process, and that is to establish the facts. Also, and more importantly, I say again, that I do not decide what sanctions are brought, and quite rightly so. That is for others to decide. Without wanting to steal the thunder of the Chief Risk Officer, Catherine Jane, who will address you tomorrow, she has drawn my attention recently to one very important statistic. From October 2015 to October 2016, there have been approximately 250 risk mitigation actions raised with firms. In less than 3% of these cases have been referred to enforcement as a result of this. So I think that's a pretty alarming statistic, or pretty good statistic. To follow on from this, as you can see from the slide, from those referrals, as of today, there are only 25% of cases that have been referred where sanctions have been brought against a licensee or individual this year. We have referred 37% of cases back to the supervisory divisions after our investigation was complete, as we felt that the findings did not warrant a proposal of sanctions being brought before a case review panel. And we felt that the findings made during the investigation phase would be best dealt with by the supervisory divisions to remediate certain matters. So please, I do not want to have to try and defend this year on year, but rest assured, there are enough checks and balances in place to ensure that only the most serious cases are taken forward, where we may seek to bring sanctions against those that have not carried out their regulatory functions in a manner which we would expect from them. And on that happy note, that is it from me for another year. Thank you very much.